Lordship's leave may I mention a case from the DT instruction. Serial number 10. There's an IA for modification of order. Filed by the applicant.
What modification?
Which is by order dated 3/10/25. Your Lordship had declared the appeal as abated against respondent 8. But respondent 8 had been substituted as a prior date. So the appellants have, I am the respondent in the case. The appellants have filed the order for modification that the suit has not abated. Actually, it was substituted. Yes, 11/1/23 order. The name of respondent 8 had been
That we can modify. Yes, ma'am.
Yes.
I mean, another piece. I'm mentioning another business. From
Serial number 10.
Yes.
Serial number 10 post tomorrow. We passed the order to hearing that. Yes.
Serial 10 is
well, today's release from 215. First is WPL 873 of 2016. This pieces parallel to what he is in this photo. I don't know. Not 215. Today's test.
There is only one case. Yes. When does she want?
Anything next week, it's suffering from fever.
At the request of the counsel for the petitioner
item 1.
on account of personal ground of appeal counseling semi-file, let this matter be proceeded on next day. What else? That's all.
From supplementary list for orders with effect item 3, first appeal 2 of 2022.
Yes, what are the defects?
Defect number 3, for which I have given an IA 2346. In fact, this is regarding award to be produced, to be submitted. Award has not been prepared by the court. So 1, 2, 3 were regarding award. Certified copy of the award was, because award has not been prepared in this case by the court. So it has been, one has already been, one is also regarding mentioning of award dated. So that was ignored by the.
Where have you stated that award has not been prepared?
In
Where have you stated in your idea that award has not been prepared? Verified. What about defect number 3?
award has not, yes. And about
What about others? 2 and 3 are the same?
the same matter regarding defect award.
IA number 2346 of 2023. In FA number 2 of 2022. Counsel for the applicant has submitted that the interlocutory application has been filed for ignoring the defect number 2 and 3 in view of the fact that both are related to preparation for both are relating to filing of the award passed by the learned court, but the award has not been prepared.
Another IA is there.
Just a moment. Considering the submissions like IA number 2346 of 2023, is it required to be prepared or not required to be prepared?
Required in every case.
Yes. Then why award has not been prepared?
It is known to be court below.
Let a report be called for from the concerned court as to whether award has been prepared or not. If it has been prepared, a copy of the same will be forwarded to this court. Post on
Let's see one.
just a moment. Post on 14 July. What else?
IA number
5698.
5698 for substitution.
Substitution. Whose substitution?
My apparent sole appellant died.
When? On 23/2. IA number 5698 of 26. Counsel for the appellant has submitted that the sole appellant has expired on 23/2/26. And
It's an only son.
his only son
Paragraph 4.
be substituted. Wakalatnama has been annexed along with the interlocutory application. The death certificate has already been placed on record. To submit that the prayer for substitution has been made within time. Within time, no? Considering the submissions, the prayer for substitution of the applicant number 1 is hereby allowed. The learned counsel for the applicant is directed to delete the name of the applicant from the first title and insert the name of his son, who is given here, namely son, namely his son, in cost, in his son Sanjay Kumar Jain, in cost title. In writing during the course of the
Another defect has been
Are
pointed
you
out.
allowed? Yes. What different?
But defect number 5, that is not in the Apalatnama, in the headline, it is in the High Court of Jharkhand. It should have been in the name of the original appellant. That is to be corrected. It was printed.
Defect number?
Defect number 5, is subjected to printed form था तो उसमें हम
Okay. The learned
ऐसे हम
counsel
काट दिए judication.
कर दिए correction.
पहले ही काटे होते लेकिन फिर भी जो पॉइंट आउट किया गया है तो है.
The learned counsel for the applicant is permitted to remove defect number 5 during the course.
हाँ, in course.
हो गया? अब कुछ बचा?
और कुछ तो अभी नहीं. Limitation. Limitation is there, but officers point out that there is no limitation. I have filed along with the memo copy.
22 में फाइल किए हैं ना?
हाँ,
कोविड के चक्कर में नहीं होगा लिमिटेशन.
हाँ, वही. बोल अभी स्टॉक रिपोर्टिंग हुआ है कि there is no limitation.
In time.
So this is not.
The learned counsel for the appellant submits that as per the stamp reporting, the appeal has been filed on in time. The office has excluded the COVID period, that is from 15/3/2020 to 28/2/2020. He submits that in view of the office report on the point of limitation, he does not want to press the IA number 99 of 2022 seeking condonation of delay in filing the application. Considering the submissions and the records reveal that as per the office, the appeal has been filed in time. In view of this, the IA number 99 of 22 which is a petition
not
seeking condonation of delay is dismissed as not first. और बताइए
और तो अभी कुछ नहीं है अभी तो नोटिस आना दे और एडमिट कर या लॉट कोर्ट से रिकॉर्ड मंगा ही नहीं.
वो अवार्ड मंगा रहे हैं ना,
हाँ,
तो वो 14
अनंत है.
को सप्लीमेंट्री लिस्ट में डाल दीजिए.
Item 4, first appeal 166 of 2022.
Yes, Vilant. Nobody appears on behalf of the appellant. On 23/3/26 also nobody had appeared for the appellant. However, the appeal is still defeated. Time till 31st July is granted to the appellant to file to remove the surviving defects. Or to file appropriate petition in connection with one or the other defect. Failing which this appeal shall be made, that shall be dismissed without further reference to the bench. Since the applicant is absent, let a soft copy of this order be forwarded to the council for the applicant to ensure compliance.
Item 5, first appeal filing number 5636 of 2025.
Leadership, I'm only paying for a week's time to reply to the IA notification.
For the respondents,
Respondent number 1.
and what about other respondents?
Other state and the NHA.
ना लंबा ऑर्डर शीट कैसे हो गया? Yes,
Court fees वाला matter your lordship, leadership to Supreme Court में stay.
तो अभी स्टे चल रहा है.
Yes, your lordship, stays.
The learned counsel for the respondents, respond number 1, pray for how much time?
1 week, your lordship.
1 week time to file reply to the
IA, your lordship, IA 8103 of 26.
IA number 8103
03.
of 2026. लेकिन ऐसा तो कोई IA है ही नहीं इसमें, है क्या? वो substitution.
Substitution.
Post on 15 July. आपका वहाँ पे क्या नोटिस हुआ, उसके बाद क्या हुआ स्थिति में?
Supreme Court में. उसके बाद notice होने के बाद they have appeared, the respondent
They have
number 1.
appeared.
Yes, your lordship. Yeah.
They have appeared.
Any date fixed?
Yes, your
And
lordship.
10th of August.
10th of August.
10th of August.
And by this time the sole appellant died, so substitution has also.
No problem.
From date list for orders verified item 7, first appeal 260 of 2023.
Number 10 is suspending correction of lower court department.
Yes.
Lower court department correction. Defect number 10.
बाकी डिफेक्टिव खत्म हो गया सब.
पहले भी गया था मैंने उसमें कुछ करेक्शन लगे.
पहले भी गया था फिर भी अनकरेक्टेड रह गया. The learned counsel for the applicant submits that in view of defect number 10, the records are required to be sent back to the concerned court. As when it was sent earlier, it has not come back with proper correction. Office is directed to send back the certified copy of CC of the judgment and CC of the decree to the court concerned. The defect to be corrected be specifically pointed out.
Special messenger cost.
The upon deposit of special messenger cost by the applicant, the special messenger cost will be deposited by Monday. Post on 8th of July. These applicant to August. Next.
Item 8, first appeal filing number 3804 of 2026.
Yes.
पोस्ट भी जमा करना उसके लिए 1 सप्ताह का टाइम चाहिए नोटिफिकेशन के लिए आ गया.
Counsel for the applicant pays for and is granted time till 30th of June to remove the surviving defects plainly. If the defects are removed within time, post this case on 7th of July. or to file an appropriate application. File हो गया? तो कोई बात नहीं, आ जाएगा ना?
Item 9.
Same order. Same order.
From supplementary list for final disposal item 1 WPL 2596 of 2019.
And they are teaching on that level. Mr. Das, yesterday you had referred to the sale judgment. I think that is the only judgment you have read.
Yes. And my learned friend had referred to the HEC judgment.
Huh.
Now your lordship had
Was
also
on
got
7 LCC 1
page.
and bracket 1969 1 LCC 7.
My lordship has always got the overview of the dispute. My lordship, the reference comes in the references. What should be the what should be the pay scale and pay structure of the workmen of various units of Mica Trading Corporation of India Limited situated at state of Bihar, and what basis they are entitled to get their DNS allowance. This was the reference. Now, Lordship may kindly permit me to come to the pleadings before the court. That will be most important, pleading of the workmen and pleading of the management. Lordship, the pleading of the workmen will be at page number 194 of the lower court.
It has not been correctly recorded in the interim order. In the interim order, everything is recorded. Is it not correctly recorded?
It is not completely recorded. Therefore, I wanted to.
Just this. Any particular paragraph you are referring?
Yes.
Written statement of the management.
Lordship,
And?
Lordship will come to page 194. Then I will come to the written statement of the management.
194. 194. WS of workmen.
And before coming to one fact, I had missed and just tell you, Lordships. Initially, the dispute was raised for the first time on 8/8/1983, wherein, your Lordships, the demand was made for parity in the pay scale. That would be, Lordship, kindly make a note. I will refer to the document separately. That is at page 110 of the lower court record. That has a relevance because, your Lordship, take into consideration 83 the dispute was raised. Before it could be referred, there was already a settlement in 1985. And that time they got a scale which, your Lordship, had seen these scales. Yesterday I had referred to that.
Parity of pay.
Yes. It is a
This was a dispute raised in 8883.
1983, 8/8/1983. Yes.
Then settlement.
Lordship, settlement of wage settlement took place. Lordship, the dispute was raised by Mica Workers Union. That is the union who is presently sponsoring the dispute on behalf of the respondents. Lordship, the wage settlement was with the recognized trade union in 1985, wherein the pay scale was fixed. Before that, Your Lordship, the workmen were getting minimum wages as was fixed from time to time. Therefore, the grievance was raised by them that the other category of people are getting a pay scale, we are not getting a pay scale.
Okay,
Yes. Now coming to
just a
the
moment. Well, counsel for the petition has submitted that as back as on 8/8/1983, the dispute was raised in connection with claim of parity of pay scale. However, subsequently in the year 1985, a settlement was entered into with recognized trade union relating to pay scale.
yes. Another consider I also point out in 1983, as many as 16 demands were made.
So how are we concerned?
Because that dispute was referred for adjudication on a particular that what should be the pay scale. But dispute was raised with respect to 16 demands, conciliation done, failed, and it was referred for adjudication in.
That's right, we
Yes.
already have the terms of
Yes.
reference, that may not be
Yes.
multilateral.
Now your Lordship can come to the written statement of the workman request. Because they are the agreed party, they had, what was their case, Lordship? Lordship directly,
Which paragraph?
directly come to Lordship page 2. Paragraph numbers of federal away, the second paragraph on what I am reading out. What was the dispute? From the top of page 2. There, that all the aforesaid categories of workmen were originally workmen of Minerals and Metals Trading Corporation of India Limited. That while the workmen were working under MMDC, the basic daily rate of wages of the concerned workmen were rupees 5.25 in the year 1975, whereas watchman basic was rupees 5. That in the month of December 1975, the basic wage of the laborers, that is the concerned workmen, were 5.92, whereas the basic wage of a watchman was rupees 5.25. During the period, the clerks were also getting daily wages and their basics were also practically at par with the laborers, that is the concerned workmen. That this system of payment was continued approximately up to 1977. That on or before approximately in the year 1977-78, the concerned name and style of was changed as Mica Trading Corporation of India Limited. That on the full further clarification, it is submitted that approximately in the year 1977-78, all the concerned workmen, including the clerks and watchmen, became the employees of Mica Trading Corporation of India Limited. The main function and business of Mica Trading Corporation of India Limited is to purchase raw materials mica from open market and then to export it after getting the processing work done at the Mica Trading Corporation of India Limited workshop. It is also pertinent to mention here that finished goods are also purchased from the market for the export to other countries. That only duty of the workmen so far the finished materials are concerned is to inspect and to ascertain the quality and size of the materials, and if needed, some finishing work are to be done. The concerned workmen who are interested in the reference are all productive staff. That the raw materials are taken up from the source stores as per the direction and supervision of the chargeman. The raw materials are handed over to the Sardar for getting the processing of work done. The Sardar then weigh the materials and distribute among the workmen. That the workman, after receiving the material, performs their part of the job by processing the same as per the directions of the chargeman, Sardar, etc., and to obtain the same. And also that what is not in, and the same is returned to the Sardar and he weighs the materials before taking it back. That the duty of the checker is to check and supervise the finished materials, and the job of performed by the workman. The duty of the checker is also to see whether the job has been done as per specifications specified in the manual. While the concerned workmen and staff and the chaprasis and watchmen are working under MMDC, at that time all were getting the rates of wages available to the employees of MMDC. As soon as the concerned name and style of Mica Trading Corporation of India Limited, the management started paying non-productive staff. This is the grievance. non-productive staff, that is clerks, chaprassis and watchmen and daftaris of MMTC pay scale to that productive staff of the management started paying much less wages, that is the Bihar minimum wages. So the grievances others were getting pay scale, we were getting as per the Bihar minimum wages. The concerned workmen who are productive staffs are also entitled to the MMTC pay scale, which is given to the non-productive staff, that is clerks, chaprassis, watchmen, and daftaris. The union demanded that workmen, that is mica processors, should at least get the pay scale of rupees 500. Russia not reading out in that till 730 in 1985. And the union further demanded that the checker and the sardar should get the pay scale of 640 to 910. The union further demanded that the chargeman and the carpenter should get the pay scale of 700 to 1250, that with effect from 1985. The union, along with the written statement enclosing the pay scale of productive staff, which we marked as Exhibit W1 and we treated as part of the written statement, the union also is also enclosing the office order fixing the pay scale of clerk, watchman, chaprasi, and daftari, and being marked as Exhibit W2. Though they pray that it should be marked, nothing has been marked as I stated yesterday, and be treated as part of the written statement. The union further submits that the concerned non-productive staff such as clerks, chaprasis, watchmen, peon, daftaris, etc., since they are getting higher wages, since 1979 they are getting higher wages, that is the date of change of name and style of MMTC to MITCO. The union prays before your honor to direct the management to produce comparative chart of the basic wages of all the concerned productive staffs and non-productive staffs, that is clerk, peon, chaprasi, daftari for the period 1979 to 1985. The union further submits that concerned workmen are entitled to the DNS allowance at par with the other employees of such as clerk, peon, watchman, daftari, etc. The concerned workmen and the non-productive staff such as clerk, daftari, peon, watchman, etc. are working in the same place and purchasing their necessities from the same market, hence are entitled to the same rates of DNS allowances. Lordship, permit me to pause here for a moment. Till now, Lordship has seen they are claiming parity in scale not with the people who are doing alleged to have been doing similar duties, but they are claiming parity with dissimilar category of employees. Lordship, can you take note of that? That the union prays that your honor may direct the management to pay the concerned workmen DNS allowance at par with the clerks, peon, watchmen, chaprasis, and daftaris, that the action on the part of the management in not paying the concerned productive staff the pay scale rates of MMTC and at least at par with the pay scale of clerk, peon, chaprasi, daftari, etc. was illegal, arbitrary, unjustified, and against the principles of natural justice, as also against the principles of equal pay for equal work. That the action of the management in not paying the concerned productive staff at least at par with the non-productive staff like clerk, peon, daftari, etc. is discriminative of in the nature and smacks of anti-labor policy of the management. The concerned non-productive staff are previously getting wages less than or at par with the concerned productive staff, but curiously enough, the management all on the sudden paying the non-productive staff wages more than the productive staffs under facts and circumstances about the union on behalf of the management, prays that your honor may answer questions in favor of such. So, Lordship, the admitted fact is they say that we are entitled to get the salary at par with the clerks, daftaris, and the watchmen, who, as per their point, were non-productive and productive. Their thinking is we are directly taking part in manufacture of the products, and they are not taking part. So their contribution to the company is less. So we should be paid at least at par with them.
The learned counsel for the petitioner has placed a written statement filed by the workmen represented by MICA Workers Union and has submitted that the specific case of the workmen of the concerned workmen was that they were involved in not in productive work and were getting and were previously getting who were they and the pay scale of non-productive staff was fixed, but their pay scale was not fixed.
Yes.
And they were seeking parity with non-productive staff. Yes,
My lordship, can you
in the matter of fixation of pay scale and also in the matter of payment of PNS. ये है page 194 में है विनीत जी till 199. Yes, what else?
My
This
lordship,
has not been properly recorded. Which paragraph has not been recorded in the
no,
interim order?
it has been recorded in a summarily.
Yes.
Therefore, I
I
wanted to
think
show you lordship the
everything
paragraph.
is recorded in the interim order. It is recorded. As when I read it, so I
Lordship,
just trying to
but
figure out.
small details of on what basis they are claiming.
We are not first appeal.
No, lordship is not in first appeal. I'll just show the basic, what is the basic case and what is our case and what has been adjudicated. And what is the law on the issue. But you may read the WS of the management. I'll skip from page up to para 5. Till para 5, lordship, readings are with respect to who would be the lordships. Concerned government to bring them. Now, lordship, coming up to para 6. The alleged industrial dispute. It will be at page 150.
Yes, it is there.
The alleged industrial dispute referred for adjudication is covered by a settlement dated 23/7/1985, which is still in force. Specific plea we have taken. All the workmen had taken the advantage and benefits of the said settlement without any protest. The settlement has not been terminated as required under section 19 of the Act. Not just suppose somebody says that it is not a valid settlement or not a genuine settlement, they can get it terminated.
Perhaps that is not the case.
No, they are silent. They have not stated anything about that settlement.
The point is that both of you are filing the written statement. It is not a response.
No, they have given a response to our statement also because we felt
We'll
that
see that.
we accept them.
We'll see that.
The settlement has not been terminated as required under section 19 of the Act. As such, the reference is bad in law and not maintainable, and the learned tribunal cannot proceed with the reference for this reason as well. The statement of demand sent along with the notification dated 8/8/1983, which stands completely satisfied by the settlement dated 23/7/1985, which has been given a retrospective effect from 1/7/1984. So we also inform that they made the first demand in 1983, but subsequently there has been a settlement giving it, which was with a retrospective effect. The state government has not applied its mind while referring the dispute in failed to appreciate that no dispute was raised by the recognized trade union, electronic work trade union, leading, which is the party to the said settlement. No such demand has been referred was ever placed upon the management, and the reference is bad for this reason as well. So this part they admit that we have not given to the management. I'll show you.
No, but the reference is bad. That is not the issue to be decided. The reference is valid. That is not the issue. Now only two issues are there.
Lordship, if the
Whether-
reference is bad,
No,
Lordship,
you see, you cannot reopen everything. Now the demand is confined only to 2 points. One in the LPA, whether it is covered by the Industrial Disputes Act or not. And second is by the observation of the Honorable Supreme Court. That's it. Now you cannot open the open all the issues.
as
I'm trying to this.
the MICA Workers Union has a very little following among the workmen and MICA, as such it is not valid industrial dispute, though could be raised by this union. Reference is bad for the reason also that the workers engaged in the entire MICA trade is governed by the provisions of Minimum Wages Act 1948. The state government of Bihar from time to time appointed MICA Wage Board, and latest wage board was constituted in the year 1981, and the board finally submitted the report on 30th April 1983. The report submitted by the wage board was published in the Bihar Gazette on 8th August 1984. That's I'll just indicate. For minimum wages, there is a common notification. For MICA industries, there is a separate MICA industries wage board by the state government, which prescribes minimum wages to be given to the MICA industries employees only.
So under this, so everybody was getting under the minimum wages prior to the settlement.
Prior to the settlement, yes.
Everybody was getting under the minimum wages.
Minimum wages.
There was a separate category for both of you.
So there was a separate category of the workmen who are engaged under the MICA industries.
That's right.
Yes.
Was there any separate category of production and non-production
Productive and
workers.
non-productive is the word coined by them, Your Lordship, saying just to give an
So
impression.
all of them are to be uniformly dealt with under the minimum wages.
Separate
Act.
category, scale will be different. Lordship, scale of
Scale will
clerk,
be different.
yes,
Scale will be different.
scale will be different.
But
And I'll also
but
indicate
they
one-
are entitled to a pay scale.
they are entitled to a pay scale, they have been given a pay scale.
You have been given a pay scale.
Yes.
From where are you saying?
Lordship, from the settlement I'll show it.
No, settlement means what? You say that they have been given a pay scale.
Pay scale, I will coming to the pleadings also, and we have been stating that the pay scale which was given subsequent to 1985 settlement is much more than minimum wages. That also we have stated.
So you must have
Read
you must have exhibited the pay scale
Yes,
which is being given to them before
yes,
the court
yes.
in your evidence.
Also, no document has been marked as exhibit by
That's
the
right,
court,
no
but that has been
document
on record. I'll show that document also. Yesterday I had shown it to you, Lordship, the 1985 settlement.
The settlement is which is one thing to say that they are governed by the settlement and it is applicable to them also.
And we have
It is
been
another thing to say that they are not whatever it is. Now they are absolutely out of the settlement. And now, in spite of the fact that they are out of the settlement, it is still binding on them. दोनों अलग बात है ना.
हम दो चीज बोल रहे हैं कि 85 का सेटलमेंट को ये लोग एक्सेप्ट कर लिए हैं.
एक्सेप्ट कर दिया है तब तो इनको पे स्केल मिल गया होगा.
मिल गया था.
कहाँ
वही तो
से?
बोल. Lordship, kindly come to page 4 again. I am reading.
Where have you stated that
Yes,
the
kindly
scale
see.
has been provided to them?
Yes, kindly see. Para 6 of the written statement.
Para 6 of the
Written statement I am reading.
yes
150. Page 3, internal page 3.
yes.
The alleged industrial dispute referred to adjudication is covered by a settlement dated 23/7/1985, which is still in force. All the workmen has taken advantage and benefit of the said settlement without any protest.
That is their case, they are saying.
No, no. Then you have to show no. Even they are getting a pay scale of this nature.
I'll come to the annexure also. I'll show you.
And
And we have got the present pay scale also. The pay slips of only 5 workmen are presently in service now. All have taken VRS or all of that. Because Lordship, take into consideration, mica is a dying industry for the purpose of because of the state policy. That's only 2 things. If I am
it's
not
too strong a statement.
I'll tell you,
Because of the
mica.
state policy,
I'll tell
mica is
no,
a
no.
dead industry.
I'll tell you, Lordship, why, and it is on records. After 1982, Lordship, Bihar, Jharkhand, Giridih area has a huge deposit of mica. Even today, mica is being exported. But Lordship will be surprised. After 1982, there has been no renewal of mining lease of mica. There is no mining lease. Government companies cannot do illegal mining. Now, Lordship, in the Bihar mica rules, there is only one provision that debris which have been collected by the villagers can be sold. Taking advantage of that clause, also various business families, various businessmen, they do illegal mining on the pretext of that debris and they are exporting it. But as on that, there is no legal mining of mica in the entire state of Jharkhand since 1982. There is not a single lease renewed.
Fire PI.
I'm just telling you. Therefore, this industry has died because of the Lordship, that
State
there has been no
policy.
state policy not to renew any mining lease. And despite the fact, India still Lordship exports privately. Not Lordship, initially there was a policy why Mitco was there that anybody who wants to export mica from the country, Lordship, they have to export at least 60% of the mica channelized through this company. Otherwise, they cannot export. Lordship, after VP Singh government, everything has come in the pleading also. Lordship, there was a change of government, they removed that restriction. And thereafter, Lordship, there was no renewal of any mining lease. And it is still continuing privately. So all the government companies became sick. And Mitco was concerned, Lordship, not that Mitco was a trading concern. They used to buy mica, finished product and sell it and export it. MMTC, where these workmen are, they had a small workshop where they used to process the collected mica.
Come to the point.
Yes.
So according to you, they are covered by the wage agreement
Yes.
and they are also being paid as per the wage.
As per, yes. The settlement has, therefore, also I was in page. So that part I have shown you, Lordship, that they have
Yes,
taken
the
the
learned counsel for the petition has been referred to the written statement filed by the management and has submitted that as per the written statement, the workmen involved in this case are also covered by the settlement made in the year 1985. And Therefore, they are also getting the pay scale, their wages as per the pay scale.
Yes. Thereafter,
Settlement dated 23/7/1985. Here, page number 150. Yes, please.
so thereafter, I'm not reading each and every line in also, that's waste the court's time. So para 10 to paragraph 14, we have stated that there was a special mica wage board for the mica industries. They had published and they had prescribed minimum wages. Huh? Now, Lordship, kindly come to para 15, page 156. The wage report having examined entire wage board report having examined entire working of mica trade beginning from the mica operation, sorting, finishing, and finally export, came to a conclusion that no liberal wage structure can be recommended except the minimum wages. This is by the state of here. Now, Lordship, kindly mark para 16 that Mitco is paying its worker more than the minimum wages prescribed by the government under the previous Minimum Wages Act 1948. Hence, no revision of wage structure can be made unless the paying capacity increases. We give a specific statement that though Bihar government had formed a wage board which has made a recommendation, but we are making payment more than what they have recommended. The management asserts that it is paying higher wages. Para 17A. The management asserts that it is paying higher wages than those paid by other unit of the in the industry. The wage structure, dearness allowance, and other service conditions are uniformly applied by Mitco to the workers similarly situated in all the states. There is no revision of wage structure in the states. Hence, no revision of wage structure and DA can be made only for the worker employed in the state of Bihar. For this also, the reference is bad. Since much of the revision has not, the court did not say that we should revise. Since the mica trade is fully dependent on foreign orders and demands no additional benefit can be given to the mica workers at par with the other workers engaged in the core or other trade, which can be both domestic and foreign market. The exports made by Mitco in course of last 5 years shown continuous decline in the trade, and future of the trade is very insecure, and there is no addition. As such, no additional burden can be settled with by any state way of wage increase or rise in dearness allowance, as is evident from Annexure 1. The financial position and profitability of the corporation is deteriorating every year on account of slum of in mica trade, which is evident from Annexure 2. That Steel Mica Trading Corporation is paying more than the minimum wages fixed by the government together with other allowances to its workers, which is much higher than those paid by the other industries in the to the workers engaged in the trade. On the account of slum in mica, many expenditures engaged entrepreneurs engaged in the mica trade are already wind up their mica business, and others are in the process of being wind up. Mitco has no capacity to bear the additional financial burden.
So,
The rate of-
as per the written statement, the concerned workmen here are treated at par with everybody.
The pay scale will-
As per the pay scale and as per the,
Yes.
so under the settlement, what is the pay scale given to them?
Lordship, the employees with whom they are claiming parity.
No, you forget about the parity.
Yes.
You refer to the settlement.
Lordship,
What is the pay scale given to
Lordship, they are
them?
out of settlement. They are not in this settlement because they are not in the industry, not engaged in the industry.
So, you can't have it both ways, no?
Lordship,
You
they-
say that they are out of the settlement.
Lordship, there
On the
are
one hand, you
in
say that
any
they are
industry.
getting as per
Lordship,
the settlement.
in any industry, there are two categories of workmen: unionized and non-unionized. Unionized workers who are governed under, come under the
See, as per your written statement,
yes.
they are governed by the settlement.
They are governed by the settlement. There are categories of employees.
By their exclusion.
Also, there may be categories of employees who are not
Which
unionized.
category? I want to know.
Who are not workmen, who cannot be a member of a party to a wage settlement.
You say. It
But
is
the
one
wage
thing to,
settlement, yes.
Mr. Das, it is one thing to say that they are not a party to that wage settlement, or they are not covered by that wage settlement. The moment you say that they are covered by the wage settlement,
Lordship,
The
can we come to
moment-
the settlement once again?
the moment you say that they are covered by the wage settlement, then under such circumstances you have to say that what is the pay scale being given to them.
Yes, I am coming to it. Lordship, can you come to page 3? I misunderstood this. Lordship, clerks pay scale is not mentioned here because clerks are not workmen. ये लोग जो क्लर्क का बोले थे प्लीडिंग में, क्लर्क लोग वर्कमैन का डेफिनेशन में नहीं आते हैं. कोई भी ऑर्गेनाइजेशन सीसीएल में भी होगा तो वेज जैसे एनसीडब्ल्यूए का में ये लोग नहीं रहेंगे. वर्कमैन रहेंगे।
तो
मुझे
इनका
भी
खाली
नहीं-
पे स्केल बताइए ना
हाँ।
कौन सा?
इनका कैटेगरी 1, कैटेगरी 2, 4-5 पे स्केल है।
सर इन्हीं लोग का है।
इन्हीं लोग का। मतलब ये तो बताया नहीं ना कि whom या which category of workmen they are sponsoring। ये तो वेग इनका। इनको बार-बार मांगे कि आपका कौन वर्कमैन है। लास्ट में जाके 47 वर्कमैन का लिस्ट दिए। उन 47 में अभी हम लोग वेरीफाई किए थे, 5 ही अभी है। Lordship, just tell. Lordship, kindly come to page 354. One moment. पेज 353 से सेटलमेंट स्टार्ट है। जितना वर्कमैन एंगेज मतलब वर्कमैन है इसमें इंक्लूडिंग ऑल whom they want to cover will come under this। Yesterday what you said it is page 353 it starts। So the relevant portion will be page 354। So category 2 pay scale is 210 to 245 as what you got it। Category 2 what I'll just explain is unskilled workmen। Category 1 235 to 280 they are the skilled workmen। Checker to what they have explained in the written statement who is the checker। Checker 245 to 300। Sardar public munshi 270 to 345। Carpenter 300 to 385। Chargeman also they have explained who is the chargeman 340 to 450। This is the pay scale they have done।
This is the pay scale which they are getting.
Yes।
From where do you say this, that they are getting the pay scale as per this particular?
You have stated it in para 6 if once again I am reading
Okay,
that they have
that's
taken
right.
advantage
This
of
is
this।
what you have said,
Yes.
and what is the evidence to this effect?
Yes, I'll come to the evidence later. Let me complete the pleadings, deposition, our witness, and they have also admitted they are getting the scale. They say we are not getting it at par with them. I'll show it from their evidence.
Right. So you have the learned counsel has submitted that the concerned workmen involved in this case were getting the pay scale in terms of the settlement at page number 353. He has in particular referred to the scale of pay in clause 6.1 and has submitted that category 2 is for unskilled persons, and rest of the categories are all skilled persons. The learned court has recorded a finding that you are not giving them any scale.
Also, that is what I want to say.
Yes, show me what is the scale.
Yes.
Where is your evidence? Maybe that they are not at par with others.
Yes, they are not
Right.
at par with
But
others.
if they have been given a scale, where is that scale?
Also, I have shown that settlement. I have shown your lordship the scale was prescribed and is binding upon us. My lordship will continue.
You said that a rejoinder was also filed.
Yes, yes.
Where is that rejoinder?
Therefore, also I wanted to take your lordship to
Where
the
is
pleadings
that?
first. Lordship, the rejoinder starts from. Lordship will kindly come to page 163.
The rejoinder to the written statement filed by the management is at page number 163.
Rejoinder to the by the workman to the written statement of the management.
Rejoinder by the workman to the written statement of the management is placed at page number 160,
163.
163. Admission दिखाइए क्या कुछ दिखाइए?
Admission नहीं है. जो वेट डिनाई की है इसमें. Also, can we come to page 3? Paragraph. Page 3, first paragraph. This is in reply to statements made in paragraph 6. The statements of the management in paragraph 6 are false, frivolous, motivated, and hence denied. It is submitted neither the alleged bipartite, they do not deny the bipartite, right?
Yes.
Neither the alleged bipartite settlement as is a it should be is as likha gaya as a settlement under ID Act, nor it is binding on the members of Mica Workers Union. It is submitted that alleged settlement does not cover the present reference. This is that they do not say that we are not getting it. That part they have not replied.
So it can't be like this. ऐसा admission नहीं है. If they are getting, you have to just demonstrate that they are getting this pay scale. You just tell me from the records what pay scale are they getting.
So may I finish the pleadings first?
Yes, you finish.
Thereafter,
What
because
else?
once I go to the evidence,
What else? Which paragraph do you want to refer? इसको तो first appeal आप बना ही दिए हैं, लेकिन आप कर ही दीजिए इसको first appeal को तो.
ठीक है तो नहीं करते.
You
pleading
tell
नहीं
me which you say. We are straight away at the crux of the matter. You say that they were being paid a particular pay scale.
करते.
You show me that which pay scale was being paid to them.
Yes. But pleading we have shown that we have stated that we are paying. That's the
That's-
admission on our part, and we cannot resell from that admission. If anything has not been paid as per the then Lordships, we are bound. We cannot say that we will pay something less than what has been there in the pleading and what has been there in the settlement which we are relying. Now Lordship will kindly come to the evidence of
The settlement was with Electronic Workers Trade
yes.
Union.
They,
Who are they?
they are the recognized trade union. We have pleaded.
What is Electronic Workers Trade Union? What is
Electronic-
electronic about?
Mica is used in the electric industry only, and electronic workers union is the recognized trade union, and they had also appeared in this proceedings.
Okay, let us see your evidence. There are two witnesses of management.
Yes,
Where do I find the management witnesses?
Lordship may kindly come to page 218.
218.
Yes.
You have also annexed it in your writ petition
They have
It's annexed with the counter.
counter they have annexed.
because it is slightly
It is annexed with the counter.
counter.
It's a counter. Sorry, supplementary counter filed on 22/10/2024.
Page number please.
Page number 8, annexure A series.
This is the, you have only two management witnesses?
Yes.
Replace.
First one is your Lordship. The Ramdev Prasad Singh.
Yes.
In fact, factories and offices of Mitco are located in Bihar, West Bengal, Madras, Andhra Pradesh, Delhi, and Rajasthan. Mitco is under the Ministry of Commerce of Central Government. The recognized union of Mitco is Electronic Works Trade Union. Mica Workers Union is not a recognized union of Mitco. There was an agreement on 23/7/1985 between the management of Mitco and the above recognized union, above noted recognized union. The above noted agreement, which was arrived on 23/7/1985, was effective from 1/7/1984. The above noted agreement is still in operation. The terms and conditions of the above noted agreement is being complied by the management of Mitco and all workmen. On all the workmen. The minimum wages are applicable to all the Mica industries. The wage structure of Mica industries are determined under the provisions of Bihar
Just
minimum.
pause here for a moment.
Yes.
Once that settlement is done, minimum wage story
Mica industries it is general. Lordship, Mica industries के लिए
That's
अलग minimum wages है. वो general बात बोल रहे हैं.
Okay.
हम लोग तो इसको दे रहे हैं, हम लोग लिखे ही है.
आगे
The terms and conditions of above-noted
आगे-
agreement
आगे-
is being there.
the state.
The state of Bihar has constituted a Mica wage board, and report has already been submitted by the said Mica wage board. The Mica industries is dependent on foreign demand. The Jhumri Tilaiya have also taken voluntary retirement. Some words are missing perhaps. Have taken voluntary retirement. From April 1993, Mitco has been declared sick industry by the Board of Industrial and Financial Reconstruction, Government of India. The financial position of Mitco is not such as to so that word is not eligible. The demands of the workmen, Mica trade is being
Has
carried
to fulfill the demands.
maybe fulfill. Mica trade is being carried out by a private sector also, besides carrying the Mica trade, carrying of Mica trade by Mitco. So this explains why we had said that I have gone through the WS by both the parties. Ashok Panda, who has verified the WS on part of the management, is competent to do the same. Whatever I have stated to the same facts mentioned in the WS of the management, I can file documents regarding my designation, which I have given in course of my examination chief. The type of the mica processing factory, which is located in Chunditena, is also located in Huzur within the province of Andhra Pradesh and Bhilwara within the state of Rajasthan outside Bihar. I have never been posted in Huzur within the state of Andhra Pradesh or Bhilwara within the province of Rajasthan in the in any capacity. Without looking into the papers, I cannot give the previous pay scales of any categories of workmen working in the factories of Andhra Pradesh, Rajasthan, but at present the pay scale of all categories of workmen, Lakshmi and Mark, working within the province of Bihar, Andhra Pradesh, Rajasthan are the same. So we say in all the states the same pay scale is given. They have cross-examined, it is in reply to their cross. Previously, the wage of the workmen working in the factory of Midco at Andhra Pradesh and Rajasthan were being paid as per the provisions of Minimum Wage Act, but at present the Midco pay scales are applicable to all the factories of Midco. Without looking into the papers, I cannot say if minimum wages of Bihar, Andhra Pradesh, Rajasthan are the same or different. I do not know if the pay scale of the workmen working in mica factories in Andhra Pradesh, Rajasthan are higher than that of the pay scale of night guard or daftari. It is not a fact that the pay scale of all the mica factories all over India are not the same. I have no knowledge if there were any secret voting for determining the number of workmen in different unions. The management of Midco never asked the different unions of the workmen working in mica trade to submit the list of their workmen of their respective unions. It is not a fact that management of Midco gives recognition to the property union. It is also not a fact that mica workers union is the representative of a union who has got membership of maximum workmen. It is not a fact that electronic trade union has got no workmen in its members. I have got no knowledge if the management of Midco used to give expenses for coming and going to the tribunal to see who is the president of electronic trade union. It is not a fact that mica workers union and workmen of in general had their protest to the effect that the electronic trade union cannot arrive at an agreement with the management of Midco or Bihar. It is not a fact that agreement arrived on 23/7/1985 is not legal. It is not a fact that the statements made to the effect that the export in pursuant to foreign trade went on decreasing and in the year 1989 there was total stoppage of foreign demand is not correct. Without looking into the papers, I cannot give the number of officers and staff working at Midco Industries located in Bihar. I do not remember if the export of mica is totally stopped since in the year 1989. Neither the officer nor the staff has been retrenched by Midco. After 1989, the meal allowance of the officers and shift allowance of the staff has been stopped. Prior to the close of mica unit, no closure notice was issued by the management of Midco. It is not a fact that no unit has been closed. It is not a fact that the workmen working in the mica industries in Midco, after taking voluntary retirement, joined the private mica trading industries, as the pay scales of the private mica trading industries are much more than the pay scales of mica industries of Midco. Without looking into the papers, I cannot give the number of officer staffs who have taken voluntary retirement. It is not a fact that number of workmen who have taken voluntary retirement is not correct. As per the present scheme of voluntary retirement can be stopped.
Mr. Das, you just come to that paragraph which says that they are being given
Yes.
a particular list. Rest is not relevant.
Yes.
Rest is absolutely irrelevant. You just tell me which paragraph of the management witness say that this scale is being paid to the concerned workmen and they are being paid as per the scale.
Lordship, can you come to the first paragraph itself? Lordship, that there was an agreement on, Lordship, it is in the fifth line.
Yes.
There was an agreement on 23/7/1985 in between the members of Midco and the above noted recognized union. The above noted agreement which was arrived at was on 23/7/1985 was effective from 1/7/1984. Above agreement is still in operation. The terms and conditions of above noted agreement is being complied with by the management. So we say we are complying with this agreement.
So what nature of worker is getting what pay scale?
So that is mentioned in the agreement itself. settlement itself, which has been proved. And Lordship, can you take into consideration this apart? They have cross-examined us, wherein they kindly see para 12. Their cross-examination nature of they do not question us that you are not paying.
No,
They say
because
that
you have not said that you are paying.
Lordship, we have stated in
That is absolutely vague. We just want to know, it was their specific case that they are being still paid at minimum wages and they are not being paid the pay scale. As per the
Actually,
pay
the
scale,
return
nothing is being paid.
Yes.
Their case was that they are still getting the minimum wages and they are not getting the pay scale.
Lordship, can you see in the written statement what they have stated? They have stated that we are entitled to the scale of such and such, not in the scale of such.
But at the same time, they also say that they are getting the minimum wages.
Now the fact is, if they were getting minimum wages, at best Lordship court below would have held that they are entitled as per the settlement to this scale, would not have prescribed a third scale which is not even
They have
mentioned
not
in it.
prescribed the third scale.
Yes, 500 rupees a scale has been prescribed. Can you see the award?
500, is it one of the scales?
No, it is not a one of the scale over here. They
500
say it is
rupees.
at par with the Lordship. Therefore,
The impugn order is rupees 500.
yes,
Let us see.
can you see the impugn award? Therefore, I say that scale.
No, let us see. Where is
Yes.
the impugn
Lordship,
order?
I
It
kindly
says
come
it
to-
that they should get at rupees 500.
Yes, Lordship may kindly come to last paragraph, page 39 of the award, which would be page 103 of the writ application. Consequently, the pay scale and pay structure of the concerned workman should be as below: 515 to 730. And why it has been given? Kindly see your Lordship the penultimate paragraph. Para 51 onwards. Although the claim and demand is for granting pay scales of the workmen from non-production side, the details regard which has been given in the written statement as also one of the documents produced. But it has come in course of proceedings and the learned counsel appearing on behalf of the workmen submitted during arguments that though the concerned workmen claim that they are entitled to get more than that being paid to non-productive workmen, and if not, then at least at par with their pay scale, but considering the circumstances now at this stage, they are ready to further confine their relief to the extent that at least they should put in the same scale as that of watchman, daftari, peon. So they claim equality or parity with respect to a different class of employees.
No. You see, they say that they were getting earlier more, but they have said that okay, whatever it is, at least at par.
Yes.
So
Also-
therefore, if it is at par, then under such circumstances, it is watchman, daftari, peon, etc. are covered by that settlement. Whatever they are getting, they will also get.
I'm coming to it. Now your Lordship, if your Lordship wants to give them same scale.
I don't want to give them. I just want to looking at the
Yes,
award.
this award, if the award is to be upheld on this basis that previously they were Lordship, there are
You
direct
see,
judgments.
you should be happy. Considering your argument, you should be happy if it is held that they are covered by the wage agreement.
A can be compared with B, but A cannot be compared with 5.
You can't have it both ways, no?
Lordship, kindly-
You say that they are covered by the
Settlement.
Settlement.
If the
Se-
settlement
if the settlement is there, and you say that all these categories of workmen are covered by the settlement, so they are entitled to one or to be placed under one or the other pay scale.
yes,
Yes, they are entitled to be placed on one or the other pay scale.
whatever pay scale they are in, whatever category they belong to.
Yes,
If
naturally.
they are unskilled, they will get the scale of unskilled. If they are skilled, they
There
will
is,
get the
there is no two classes as skilled and unskilled.
category 1, category 2. Lordship has seen that.
Category 1 does not say that it is unskilled.
Lordship, whatever, but suppose a person is category 1 employee, he cannot claim the wage of category 2 employee. Category 2 employee cannot claim the wage of any other category. He can claim the wage to which he belongs.
But which category they belong is also not clear from the records. They say that they have been working as various.
Production. Lordship, they have said that, Lordship, their interpretation is if a person is directly involved in the manufacturing process, they are productive workmen, they contribute to the production. Others are useless workmen, non-productive workmen, because they are clerks. They are working. They may be educated, but they are non-productive.
You
This
just
is the-
see. You just come to page number 21 for a moment.
of the award.
Yes, of the award. These
As
are the categories. Category 1, category 2.
Yes.
Record, right? This is as per the settlement. Now
As per
come
the
to
settlement.
come to the next question.
as per the order of Medco dated 13th October 1987,
Hmm.
W2, pay scale of non-productive workmen shown below is assistant, junior assistant. Lordship, they cannot compare themselves with this category. That is what our case is. And Lordship, I'll satisfy you, Lordship, in n number of judgments that if A can compare himself to the similar category, he cannot compare or claim a pay scale of a different category. Lordship, there cannot be a judicial review of the Lordship who should be paid more. Because Lordship, one analogy would be
You just tell us, according to you, they were working as what?
Lordship, they all were amongst category 1, category 2, checker, Lordship, Sardar, they all are their own pleading is they are in the productive category.
No, para number 6 of the award
Yes.
at page number 3.
Yes.
Further cases, a concerned workmen and the staff in Chaprasi were working under MMTC and they were all getting the rate
Yes.
of wages available to the employees.
Yes. There are cases that at one point of time our scale was either comparable or more than the other category of people. But subsequently on revision, we have been placed at a lower scale. This is their case. We are getting less because we are getting as per minimum wages, they were getting as a scale. That is in 1983 when the dispute was raised. In 1985, they were given a scale.
Yes, madam, you just tell me that in what capacity they were working. What was the category in which they were working?
They were working as a chargeman, carpenter, sardar, munshi, checkers.
Where is it?
It is our case, your lordship.
Where is it?
Yeah.
Yes, at the bottom. Page 1 of the award. At the bottom, right? Since long on the post of chargeman,
Carpenter,
carpenter,
sardar, munshi, checkers,
Sardar, Munshi, checkers, and mica processors.
and workers. Yes,
And
mica.
mica processors,
Mica
right? So you just tell us each one of them will fit in which.
Page 21, yes, Lordship.
Yes.
Checker
Page
also
21. Checker is specifically mentioned.
mentioned, Sardar Munshi is mentioned,
Sardar Munshi is mentioned. Carpenter is mentioned.
chargeman is mentioned, and category 1, category 2 are the workmen.
Category 1 and category 2 का इसमें से कोई नहीं.
And workmen जो बोले हैं,
नहीं, workmen कहाँ बोले?
Mica
Lordship,
नहीं है.
mica
Yes, mica processors.
mica processors, they have framed something in yes. Lordship may kindly come to their own written statement at Lordship page 196.
Yes.
That part I had read. I am reading it. Internal page 3 of it.
196.
That the
Yes, 196.
Lordship, second paragraph, that the concerned workmen are interested in the reference are all productive staff, that the raw materials are taken up from the source as per the direction supervision of the chargeman. Chargeman is included. The raw materials are handed over to the Sardar for getting in process. The Sardar weighs and the materials are distributed amongst workmen. The workmen are after receiving the materials perform their part of the job by processing the same as per the direction of the chargeman and Sardar, and obtain the same are returned to the Sardar and again there. So they have not explained anything about.
No, but specific category they have mentioned,
Yes.
right? They were working at this category. Now, all these categories are covered except the processor.
Processing.
Processor has not been specifically mentioned. Rest of all the categories
Yes.
are mentioned.
Yes.
So, according to you, they are covered by this category.
Yes, this category.
And they have been given the category of peon, watchman, and daftari
Yes.
by this impugned order, which is the dated 13th of October 1987. Right?
Yes.
Yes, madam. When there is a specific category for you, how will you be covered by this category?
Your ladyship, my first and foremost contention with heavy reliance is being placed on the settlement. But my contention since beginning, since in my rejoinder, I have stated that we are not the party to that particular settlement, and that settlement is not governed us. Even the learned Labour Court has stated that during the pendency, the matter was referred to the dispute on 8/8/1983. So, and the reference was made in the year 1987. So, 5-year duration were there. a 4-year duration. During this period, in the year 1987, they entered into a settlement with the some or ex union, and then they are saying that it is binding upon us. Since beginning,
No. You see, it is not binding upon you, right? Because you
Yes.
say that you are not a party to it.
we are not.
You are not a member of that union. You are not a party to it. So you are claiming parity.
No, Your Ladyship, this is not my case. The Learned Labour Code
No, what is
has
it?
stated that considering the financial position,
No,
at
no,
least they should
yes.
get in parity with that. That
With
is
whom?
with the non-productive staffs.
Why? You see, when there is a specific category in a company with respect to sardar, checker, carpenter, chargeman.
Yes.
So if the pay scale of this peon, watchman, and daftari is provided to you, then under such circumstances, right, those sardar, munshi, and carpenter, etc., will be poorly placed as compared to you. In the same company, two charges will two persons who are Sardar, Munshi, category chairman will be getting different pay scales.
Your Ladyship, this particular agreement on which settlement on which that has been also considered at page 20 to para 24, page 17 of the impugned judgment, stating that this particular wage board was considered, it was placed, but this settlement never arrived at a final settlement. It was not acted upon. That is what there.
No, that is not your
No,
case.
that is
You are-
there. So, Your Ladyship,
No,
may
you
I
have
just
referred to the settlement in your written statement
I may
also.
just I
You
may
have
just
referred to
permit
the
you to read
settlement
that. I
in
may
the
just
rejoinder to their settlement also, to their written statement also.
It is
That is
there.
how two carpenters in the same organization will be placed in the different space. You can claim parity X. You can compare mangoes with mangoes. You cannot compare mangoes with oranges.
Absolutely, Your
Right?
Lordship.
If a particular category of mangoes entered into some settlement, right, and you also claim that you are also a mango, then you will be put in the same category. There cannot be, you cannot compare yourself with oranges and get the pay scale of oranges.
Absolutely,
Simple,
Your
if you
Lordship.
put it
Parity has to
simply.
be done in a similar
So
circumstances.
therefore, the order of the learned code giving the pay scale of this peon, watchman, and daftari, which are not comparable to the pay scale which has been. I can understand the Sardar, Munshi, carpenter, chargeman, they were given increment, and therefore you have to be placed in that. That is.
After
Within the
1985 was
consequences, Madam, the consequences within the same organization with respect to same kind of persons, there will be two categories.
Your Ladyship, once for my satisfaction, para 24 may kindly be seen in order, para page 17. Para 24, page 17.
Yes.
Internal page 17. The aforesaid wage report and the settlement dated 23/7/1985 are now part of the record. Having gone through the said wage report, it appears that one of the terms of reference to the board out of altogether 5 of them was regarding categorization of the workers engaged in mica industry and determination of their wages and dearness allowances. But after making exhaustive discussion over several matters and issues, the board lastly, however, came to the conclusion as mentioned in clause 65 under chapter 17, 18 and 19 of the said gazette notification that in spite of best effort, agreement could not be reached. And in the matter of making unambiguous recommendation regarding the wage structure, it is therefore appeared that the wage structure or the pay scale was never finalized or recommended, nor in terms of that only the pay scale were fixed upon settlement being arrived at. This is the same wherein this was drafted, this was done, but it never attended finality.
Is it your case in your written statement that no settlement was arrived? Your case was that you are out of the settlement.
Your Ladyship, we are
Yes, this is
we are
not with
stating
respect
that
to
we
the
are not
settlement, Alex.
governed by this settlement. First, we have stated that we are not governed by the settlement, Your Ladyship, and then thereafter the Gazette notification, Bihar Gazette notification was placed before them after having exhaustive discussion, considering each and every paragraph.
Madam, just tell me, under what provision of law you can be compared with daftaris and clerks?
Your Ladyship, they are saying that when the settlement was arrived and a pay scale was drawn, and we are saying that there is a different pay scale was granted by the Labour Code. Your Ladyship is of the opinion that in the same category, two pay scales are there. one with respect to the settlement agreement and the other as granted by the Honorable Labour Court, Your Lordship, London Labour Court. But this particular agreement, which is 1987, was never acted upon, was never recommended, was never done. There is no different two pay scales.
If it was never acted upon, if 1987,
85 settlement, this is 1985 settlement.
it was never acted upon.
That is what it is. It could not be reached in the matter of making an ambiguous recommendation. It was not
But
taken
my
at
understanding is
finality.
reading as
This is
clarified.
something else.
Lordship, this is with
This
respect
is
to
prior to
1984.
that.
This is prior.
Settlement, all this is prior to 1985. This
No, no,
is after the wage vote, when nothing could be arrived. It is prior to all this.
It is the reference is there at second paragraph, second page itself, 24/23/7/1985. It is with respect to the very settlement which is being placed reliance upon.
Lordship, clause 64 is in the 1984 Lordship's notification, that is at page 664 of the lower court record. That is with respect to the notification of the recommendation by the wage board, minimum wage board of
See,
Mica.
there was some scheme that the minimum wage will be applicable for these industries. Now there was a wage code, right, with respect to micro industries, and the minimum wages were required to be fixed. So it was revised, and so far as revision of minimum wages is concerned, there could not be any settlement, there could not be any consensus. But the settlement involved in this case, which they are referring, is not arising out of any minimum wage code. It is a different and a distinct settlement which they are referring to. And I fail to understand that how your wages has been fixed under the category of peon, workman and daftari.
Yes, Your Ladyship, for the reason that the first, again I will be arguing that this particular wage which has been determined by the settlement agreement were never paid to the workmen or to anyone else, Your Lordship. Let them show from the record that it was paid from
You see,
them. Then thereafter,
the court had no option but to answer the reference in spite of the fact that
Yes,
absolutely, your pleadings, your persons were absolutely vague. But
in
still
the
the
same,
court,
in the same Mica division, Midco, they were the non-productive staffs were getting the minimum pay wage and of 515 that is there.
that is peon, watchman and daftari.
Yes, and they were placed lower to the category of us. We have never asked for the parity, but seeing the financial condition, the labor court said that because
You see,
seeing
if the financial condition is to be seen, then the revision of all the workmen has to be done, no?
when the one category who is non-productive category, less than the productive category, when they are getting the same pay scale of the same institution, of the same industry,
No,
then
what do you say productive and non-productive? You see, the manager of a firm may not be a scientist or an engineer, but he will govern all the scientists and he will govern all the engineer in the organization, isn't it?
yes, Your
So
Ladyship,
these are two distinct skills, and you cannot say that one is inferior to the other.
I am not saying that inferior to the
Yeah.
other. One is helping the country, the industry in the production activities, and the other is just like the watchmen. Watchmen are there for the security purposes, and but my work is higher to that. Your Lordship, the categories are there.
that is what I am saying.
The carpenter's
You
work or
cannot-
it is like skilled work, Your Lordship.
You cannot compare the skill, and you cannot compare persons who are directly engaged in production and persons who are otherwise engaged in office work or maybe in a managerial post, right? The person who is at the helm of the affair, maybe the manager, will not take the spade and start digging,
Lordship,
isn't it?
Absolutely, Your Ladyship. May I just submit the small facts of the matter, Your Lordship. These workers were employed in the year 1972. Then thereafter, at that time, they were getting rupees 5.25 paise, and they were getting 5.2 paise per day on a daily wage rate. Whereas the watchman and the labor and were getting 5 rupees, and the labor and clerks were getting 5.92 rupees. This continued till 1997. When in the 1997, a manufacturing unit of Midco was, because in the subsidiary unit was.
Kindly pause for a minute. Your entire case is that at the stage of minimum wages regime in this organization, you were getting higher minimum wages than these persons. That you were getting 5 point, little more
Yes.
than
Yes,
these.
We
little
were
more
getting
than the
5.7.
watchmen and others.
Yes,
We are
little
just
more.
little more with them. And when we shifted to the MIDCO, the subsidiary industry of the MMTC, wherein the manufacturing work was started from the year 1977, then suddenly our wage were made lesser, even lesser to the watchmen with whom we were getting more pay scales. So therefore, it is our case. We are not. We never asked for a parity. We asked for a higher pay scale of them, what they were getting. But seeing the financial situation, it was decided by because financial hardship has also to be looked into. Therefore, it was decided if not anything much higher to them, then at least at par with them. That was decided by the London Labour.
So consequence would be
Because we were appointed in the same years and your lordship and the very beginning we were getting a higher wage scale. Suddenly in the 1977 we were allowed to work on a lesser pay scale without any reason whatsoever given to by the department, by the company, your lordship. And that is what their stand is, the London Labour
the
Code.
standard of fixation of pay scale was not relatable to any minimum wages. It was a distinct and a different exercise altogether.
So the petitioner are agreeing that in the same, some of them are getting monthly MIDCO pay scales, MMTC pay scales, whereas the other is getting the Bihar Minimum Wages Act as per the Bihar. This disclaimer, this differentiation on what basis they have done, because it is their case, they are admitting it that the other workers who are getting, they are getting the MMTC pay scale, whereas some are getting the Bihar wage pay scale.
No, that is not the case.
Yes, that is so. They are saying, they have stated that they, some of the workers were getting on monthly basis as per the MMTC pay scale. And that is what I am asking. I should get the MMTC pay scale because earlier I was appointed, I was the workman of the MMTC, and they was also the workers of the MMTC. Because MMTC shifted us to the MIDCO unit, which later on indulged into the manufacturing. Earlier it was only the with respect to trading. Later on manufacturing and industry also they entered into. So we were shifted from MMTC to MIDCO. However, our pay scale, their pay scale was MMTC pay scale, and our pay scale
MIDCO
was
did not take over MMTC.
no. It was a subsidiary in that unit, your lordship. It was not never taken.
MMTC
100%.
workmen were shifted to.
No, MIDCO, your lordship, not mandate of your lordship, they supplied
Yes,
loss
they were-
and
they
went to
became
BIFR,
sick.
yes.
In the year 1994,
Right.
this is not the 1994, it is pre-merger, your lordship. Pre-merger, all the talks which I am putting forth, your lordship argument, that is pre-merger stage. For the reason, therefore, the dates are important. 1972, I joined the MMTC. They, in the year 1977, shifted me to the 100% subsidiary, that is MIDCO. There, when all were shifted, some of the workers were given MMTC pay scale. They retained in that pay scale which they were given. We were discriminated and we were given the pay scale of Bihar Minimum Wages Act. On what ground that then the dispute arose. Then that was the main bone of the dispute. That why they are being given.
This particular pay scale in page 21 is MMTC pay scale or what pay scale?
Page 21. This is
21.
MMTC. Page 22 is the MMTC pay scale.
This is MMTC.
MMTC. Therefore, we said that we should also get MMTC because we were the employees, originally the employee of MMTC.
And this is
MIDCO.
page number 21 is MIDCO pay
MIDCO.
scale.
Wherein they have been given Bihar Wages Act as per the Bihar Minimum Wages Act.
No, but it is not referring to any minimum wages.
No, it is not as per minimum wages.
That settlement, but when we were shifted, it is not referring to your lordship, but this was the MIDCO pay scale was decided mutually as per their contention that it was decided between
When was the merger? When were they shifted?
Actually, in 1977.
1977 you were shifted.
Yes.
You were shifted to MMTC.
No, we were shifted to MIDCO from MMTC.
From MMTC you were shifted to
MIDCO.
1977.
Yes, your lordship.
Okay.
And even they were shifted, but yet they were continued with the MMTC pay scale, and we were not being granted MMTC pay scale. And therefore, the dispute was raised. Even there was a revision of their pay scale. MMTC pay scale they were revised to, but there was no revision with pay scale also. But then we only prayed for fixing a pay scale. of MMTC pay scale.
So may I clarify the factual position? Factual position because nobody should be, there should not be any doubt in it. 1977 also, prior to 1977, as per their own case, both parties were getting as per minimum wages. They have stated that they were getting 75.75 per day, and the other category, watchmen and others, were getting 5.25 per day.
Shiva,
That is
again,
their pleadings
In MMTC.
in MMTC. They say, Your Lordship, that they were allowed a pay scale in 1977, but subsequently they were not allowed a pay scale. They continued getting the minimum wages as was being fixed by the state government. They raised an industrial dispute in 1983.
Their grievances that the persons who were
Non-productive as per them.
just a moment. As I understand, their case is that they were employees of MMTC. They were shifted to Midco, and some of the employees who were shifted to Midco, they were given MMTC pay scale. But they also shifted from MMTC to Midco, but they were not given any pay scale.
Actually, it is not the case. I'll just read their written statement once again. Their cases initially, both all were getting minimum wages. But they have mentioned the wages also in their written statement. Subsequently, a scale was given to certain category of employees or workmen, whatever your lordship says. That
Of
is the
MMTC shifted to Midco.
the category of employees they have mentioned. Now, your lordship, their grievances, we continued getting minimum wages which was being fixed by the state of Bihar from time to time. This was their grievance in 1983. I can read out from their written statement itself.
Please.
Now, yes. Lordship will kindly come to me.
Page number? Page number 179.
Lordship will kindly come to page 194, the written statement of the workman.
Page
194.
194.
Lordship will come to the third paragraph, that last paragraph in page, that all the workmen of different units of the Micro Trading Corporation of India have been working since long in
This
the
is
post of
MITC.
MMTC.
Micro Trading Corporation of
Micro
India.
Trading Corporation.
This is MMTC or Midco?
Lordship, not
This is
Midco.
Midco. This is Midco.
This is
Maybe
Midco.
This is Midco.
Units of Micro Trading Corporation of India Limited has been working since long in the post of chargeman, carpenter, sardar, munshi, checker worker. Their workers are possessing the mica. All the opposite categories of workmen are originally workmen under the Metal and Mineral Trading Corporation of
This is
India
MMTC.
Limited. That is MMTC. That while the workmen were working in MMTC, the basic daily wage, they were not getting a scale there also. The basic daily wage of the concerned workmen were rupees 5.25 in the year 1975, whereas watchman the daily pay was 5. In the month of December 1975, the basic wage of the laborers, that is concerned workmen, were 5.92, whereas the basic wage of watchman was 5.25. During the period, clerks were also getting, they do not mention, clerks were also getting daily wage, rate wage, and their basic wage was practically at par with the laborers of the concerned workmen. Therefore, what my learned friend said and what I submitted, that previously everybody was getting daily minimum wage only as per their case. In the year that the system of payment continued approximately up to the year 1977. On or before approximately in the year 1977-78, the concerned name and style was changed to Micro Trading Corporation of
It was
India
not
Limited.
changed, Your Lordship. I may
It is
correct you.
in-
It was
I'm
not
reading.
changed, but we were shifted to subsidiary
Is
unit.
it a fact shifted?
We were
Because
transferred.
when I thought that it was taken over or maybe the
Lordship,
name
taken
was
over took place, Your Lordship, in 1993.
No, Your Lordship. May I just clarify on this status?
1970.
1963 MMTC was established. It was running. In the year
1960.
1963, MMTC was established, was incorporated. Then on 18/6/1973, Midco created a 100% subsidiary company, that is MMTC created a 100% subsidiary company, that is Midco, and thus Midco incorporated on 18/6/1973. And initially, the Midco was engaged in trading of mica only. Later on, in the year 1977, it stepped into the industry of manufacturing of mica powder, mica paper, powder, etc. And then these were transferred from MMTC to Midco. They were transferred to for the purpose of taking the work of the Midco corporation. So it was never taken. It was a 100% subsidiary company. Midco is a 100% subsidiary company of MMTC.
Okay, then further, you please read it.
This. In the year December 1975, the basic wage of concerned worker 5.92, whereas basic wage of watchman was 5.25. During the period, clerks were also getting wages, daily wages, and the basic wages were also practically at par with laborer of the concerned workman. That the system of payment continued approximately up to 1977. That on or before approximately in the year 1977-78, the concerned name and style had changed as Mica Trading Corporation of India Limited. That further clarification it is submitted that approximately in the year 1977-78, all the concerned workmen, including clerks, watchmen, became the employees of Mica Trading Corporation of India Limited. The main function and business of Mica Trading Corporation India Limited is to purchase raw material mica from the open market and then to export it after getting the processing done at the Mica Trading Corporation of India Limited workshop. It is pertinent to mention here that finished goods are purchased from the market for export to other countries. The only duty of the workmen so far as the finished materials are concerned to inspect and to ascertain the quality, size of the material and if needed some finishing work are to be done. The concerned workmen are also interested in the reference of all the productive works. The raw materials are taken up to the public stores as per the direction and supervision of the chargeman. The raw materials are handed over to Sardar for getting the processing work done. The Sardar then weigh the material and distribute among the workmen. The workmen, after receiving the materials, perform their job by processing the same as per the direction of the chargeman, Sardar, etc. and obtain. And thereafter, the same is returned to the Sardar and again weigh the materials taken before taking it back. The duty of the checker is to check and supervise the finished materials, and the job is performed by workmen. The duty of the checker is also to see whether the job has been done as per specifications supplied by the management. That while the concerned workmen and staff and chaprasis and watchmen were working in under MMTC at all times, were getting the rates of wages available to the employees of MMTC.
This is important.
While the concerned workmen and the staffs and chaprasis and watchmen were working under MMTC, at all the times they were getting the rates of wages available to the employees of MMTC. But as soon as the concerned name and style of Mica Trading Corporation of India Limited, the management started paying non-productive staffs. Last you can see after taking the non-productive staffs, that is clerks, chaprasis, and the watchmen and daftaris, the MMTC pay scale, and to the productive staffs, management has been paying much less wages. That is minimum.
This is what my case is, Your Worship.
This is the entire case.
Yes.
That the workmen who were taken from MMTC to Midco. MMTC, some of them were given the MMTC pay scale, they retained that MMTC pay scale, whatever be the pay scale, but others were not given the MMTC pay scale. So they are fighting for MMTC
If
pay
they were
scale.
fighting for, they have to lead evidence. What was the pay scale they were receiving prior to this? Absolutely, they are silent. They are saying that they are getting this scale. We should be paid this scale, and they say their only basis is that at one point of time, I was getting 5.75, 5.25, and the watchman was getting 5. They are silent on they gave a vague statement that they were also getting at par. Now your lordship will take into consideration.
May I submit, Your Lordship? Earlier there were no pay scale as such. This system, pay scale system, came somewhere later on in the 80s, 1980s.
From where do you get that they were getting the MMTC scale?
MMTC, their pay scale, it is there, Your Lordship. Therefore, the Honorable Labour Court has held that as they were getting to this, at least he should, उनका वो एक worksheet page. Wage scale उनके जो बाद में मिल रहे थे उनको वो उन्होंने मुझे दिखाया था.
This pay scale the settlement of 1985, whatever the pay scale was there, was it extended even to those who were absorbed from MMTC?
So that pay scale was confined to the workmen Your Lordship of the particular industry. So those workmen whom they are describing, their Lordship, they were not in the industry. They were in the headquarters. Clerks Lordship is not covered by this settlement. The daftaris are not covered by this settlement. They were in the headquarters. Even today, after this unit got closed, present position I am saying, Your Lordship, I have got the pay scale of all the 5 who are still working. They have been removed to Delhi because there is no industry existing as on date. They are in Delhi as on date. And their pay, what has happened, Lordship, I was also, their pay scale is the 288 to 95 pay scale. The VDS has been increased to more than 12,000-13,000, and their take-home salary as on date, because there has been no revision because of the government, but they have been compensated otherwise. Now they get, Your Lordship, a total take-home salary of around 30-31,000. They have been compensated otherwise by the circulars of the government issued from time to time, because the industry is a dying industry, and till they are achieve the age of superannuation, they are being retained in view of the BIFR direction, where we are undertaken that will not disturb their salary and wages which they are getting during MMTC times, and that we are gone.
All the
So
concern.
they have not brought an, if their case is, if the dispute they would have raised is that our taking over was detrimental to our service conditions, they should have led evidence to that effect. They had only compared themselves that we should be paid the scale of that of clerks, daftaris and watchmen.
They have not denied anywhere that the MMTC pay scale, which some of them were getting, where it is not at all in existence, as being said, that is not at all being denied throughout the case. Even the Learned Labour Code at page number wherein the pay scale has been mentioned, Your Lordship, it has been mentioned in page 191. 190. Sorry, page 90. Not a single statement they have made in their WS that MMTC, even the WS which has been written statement which has been submitted, they are saying that some of the workers we are getting on a monthly basis as per the MMTC pay scale. This is what they are stating in their statement, that some of the on a monthly basis, some of them are getting. Let me just come to the exact wording of their leadership. They are not denying this fact. They are saying MMTC monthly salary paid staff, that we are claiming parity. They are not denying this. मैं वो exact paragraph बता रही हूँ. Just management का.
The best part is both of you are relying upon the case of the other. He is relying upon the case of the other. You are relying upon the. आपको जितना simple लग रहा है उतना simple आपको दिख नहीं रहा.
पूरी तरह से, लेकिन मेरा जो case है, Your Lordship, this settlement, heavy reliance place, they are not able to show that the settlement, even there is a judgment of Honorable Supreme Court which says that irrespective of the fact that whether it is a recognized union, not recognized, they are saying that it is a recognized union and hence binding. If a reference is made, you have to bind by that reference and you have to answer that reference, irrespective that the union is recognized.
They cannot object whether the reference is to be answered.
And there is a proper procedure, Your Lordship. Section 2P says that if a settlement during the reference period, when the reference dispute was raised and when the reference has been made, if a settlement has arrived, it in a manner to be dealt with. Section 2B of the Industrial Dispute Act may kindly be seen, Your Lordship. Specific finding of the learned labour court is also there with respect to that if that settlement arrived. Why that settlement was not placed before the
In a case where in a subsidiary company, the employees of the other company are merged or taken over, then under such circumstances, do they automatically become the member of the recognized union of the company which is taking over them? Or some membership is to be given to them? Because you're talking about the recognized trade union of your company, that is MIDCO, correct? Now, do they automatically become the member of the recognized trade union of MIDCO?
Any workman, he cannot be forced to become a member of one or the other union. So workman may choose that I will not be a member of any trade union. It doesn't mean that any wage settlement will not be applicable. The workman may choose that I will be a member. Any industry, there are a minority group and a majority group, like in our association.
So settlement arrived at,
If a settlement is arrived at, and if the party, any person, any workman can also raise an objection that this settlement is not a valid settlement. Or
and not binding on me because I'm not a party, I'm not a member
not only
of this
binding,
union.
that has to be set aside under section 19. They have to raise an industrial dispute that this is a sham settlement. Lead evidence to that effect. And that settlement has to be struck down. Till the settlement is struck down, otherwise it will not be taken into consideration. For example, Central Conference Committee. There are 7 trade unions registered with respect to this industry. There is one recognized trade union. For example, last year, Lady Mazdur Sangh Lordship has seen so many cases. National Coal Wage Agreement, if your Lordship sees, it has been entered by 6 or 7 recognized trade unions because every unit there is another separate trade unions. They signed it. There are various unrecognized trade unions. If they want to challenge that National Coal Wage Agreement, which is periodically every 5 years there is a settlement, sometimes there is a delay also, they will have to get it set aside by the court.
Or say that it is not binding on them.
There has to be a declaration. No, it is not that I say that it is not binding upon me and I take. Just like if a judgment has been delivered by this court, I cannot sit at home and say it is not binding. I have to get a declaration from the court that it is not binding.
During the meeting of the wage board, it has been claimed in the order sheet also, Your Lordship, that there were altogether 16 union, workmen union were functioning.
Entire industry, mica industries in the state of Bihar. Kindly read it. Actually, it has been stated that mica is protected through government produced and sold by government industries as well as private entities. Total industries are some are organized, some are unorganized. In the entire state of Bihar, there are 16 unions. My learned friend told it, therefore I carefully read the entire file. 16 unions with respect to entire mica industry in the state of Bihar. It does not mean that there is 16 in the union in my factory. They were taken for the purpose of fixing the minimum wages. Which will see the provisions of the Act. Representations are invited from the unions, from the workmen, as well as from the management. There they say in 1984 Gazette notification, while they prescribe the minimum wage, they say that there has been no consensus with the workmen. That they pick out and the learned court below says that as if there is no consensus in the settlement. And
So
clause 64 is not, there is no clause 64 in the settlement, Your Lordship, of 1985. That clause 64 is, Your Lordship, in this Gazette notification of 1984. I will give the page number also.
So I will just like to draw your ladyship
That is at page
attention.
number 664. And their own witness, Roger, I had read only the management witness. I'll show from their evidence also. They have also admitted that their union is not a recognized union. And these apart, everything said and done, Your Lordship will take into consideration the issues. Whether, Lordship, the issue which would be, Lordship, in the rate jurisdiction and Your Lordship is deciding is whether a pay scale of a different category can be allowed to an employee of a different category. Lordship, there is one judgment of the Honorable Supreme Court wherein, Lordship, a plea of parity was claimed on the ground that at one point of time our pay scale was superior than the pay scale of the other person who has been given higher. Honorable Supreme Court said that no, that cannot be a basis to claim. Subsequently, in the wage revision board has pay commission has considered that their work is more responsible and therefore higher pay scale has been allowed.
That's what were you saying?
Section 2 subsection P may kindly receive Your Lordship of the Industrial Dispute Act.
What do you want to say?
Settlement, when a settlement is arrived at between the reference period, then how the procedure is to be followed. What is the procedure is to be followed? Because much reliance is being placed on the settlement of 1985. Page 18 of this book, Your Lordship. And Your Ladyship, yeah, may I just read it? Settlement. Settlement means a settlement arrived at in the course of conciliation proceeding and includes a written agreement between the employer and workmen arrived at otherwise than in the course of conciliation proceeding, where such agreement has been signed by the parties thereto. Your Lordship, I take a pause. Parties thereto, in such manner as may be prescribed, and a copy thereof has to be sent to an officer authorized in this behalf by the appropriate government and the conciliation officer. So a settlement have to, if any settlement has been arrived, that has to arrive between the parties to the dispute. The parties to the dispute is MIDCO and the MICA Workers Union, Your Lordship. They have not arrived. The settlement is with respect to Electronic Workers Union. That is not the parties in the dispute. Secondly, if any settlement is arrived, that copy need to be supplied to the appropriate government and to the conciliation officer. That was also not done in this case. Never a copy was given to the appropriate government or to them. Therefore, in the 1987, ultimately the reference was made. So therefore, if a settlement is arrived between the period, because the conciliation process is also being taken up when any dispute comes across to, and then the conciliation officer is appointed to conciliate that dispute. If any dispute is arrived at out of the conciliation proceeding, a copy that has to be supplied. This procedure has also not been followed. And admittedly, the settlement which is being placed reliance upon is not between the parties to the dispute.
Anything else you want to say?
Yes, first on the issue which my learned friend had argued, let me place the law, Your Lordship. So this judgment I am citing because it has taken care of all previous judgments. If Lordship says I'll cite this separately, the other judgments also, or if Lordship permits me, I'll just show it from this judgment so that Lordship I am not multiplying the judgments which I am citing. Lordship, can you come to page 166 first?
It's not the case of equal pay for equal work.
It is not their case. I'll just
Not
come
at
to
all.
the, yes, when a
They
parity.
do not say that they are doing the same work as the clerks.
No, I'm trying to satisfy you Lordship that the courts cannot determine that which, if I show that say a peon is getting a higher pay scale than me, then court cannot say that no, you are discharging a work which is more important than a peon, therefore you should be paid a higher scale than this. Whenever a claim, particular pay scale is claimed, or what should be the duty of the court, Lordship, various facets are there of the dispute. Now, Your Lordship, will kindly come to page 165 first. One by one, these several judgments have been cited here, so that Lordship, till 2017, all the judgments are before Your Lordship. Page 165, parallel 9, Your Lordship. Federation of, I'll come to their issue also in this judgment only. Federation of All India Customs and Central Staff Stenographers versus Union of India decided by 2 judges bench. Actually, this is the judgment which has been quoted. Lordship, can we come to the next page? Para 9.3. Lordship, 10 lines from the bottom of 9.3. It was therefore held that the principle of equal pay for equal work could not be translated in mathematical formula and interference in the claim as one of the projected by the petitioner at the hands of the court would not be possible unless it could be demonstrated that either the differentiation of the pay scale was irrational or based on no basis or arrived at malified either in law or on fact. So these are the grounds on which a pay scale can be interfered with. Now,
Thus, I'm still stuck as to whether they were given the pay scale as per the
They were given
settlement
the
of
pay scale, that is our
1985,
pleading.
or they were continuing with the minimum wage?
It is our specific pleading that they were given, and our evidence also that they were given the benefits of 1985 settlement, which they had taken. And
So that was your specific case, that they were given the
And they have
benefit
taken-
of 1985.
yes, both our
settlement.
evidence of witness.
Your case is that you were never given the benefit of
Never given,
1985 settlement.
Yes.
You were only getting minimum wages.
We were getting 8.10 पैसे per day के हिसाब से जो हमें उस टाइम मिल रहा था. That is what it मिला लिखा हुआ है. 8.10 per day के हिसाब से 210 रुपए monthly हम लोगों को मिलता है.
210 रुपया was the scale, which has been now been increased not to the 5% where one of them is 290.
And that too, this was getting in the year 93, 94 से उन्हें मिला था. उसके पहले अभी
Now, Your Lordship, can you come to para 10.3 of this judgment? Their case is
Yes.
from the 10.3. Your Lordship, this is the case with the state of UP versus JP Chaurasia at para 10. Your Lordship, the citation is there. It is 1989 volume 1 SCC 121. Also, the relevant portion will be 10.3. Also, 7 lines from the top. The sentence starts from in the present case. As the Lordship got that part. In the present case, while acknowledging that at one time, bench secretaries were paid more emoluments than the section officers, it was held that since the successive pay commissions and even the pay rationalization committees had found that section officers performed more onerous duties, being greater responsibility as compared to bench secretaries, it was not possible for this court to go against the said opinion. As such, this court rejected the prayer of bench secretaries as of right to be assigned the pay scale equivalent to or higher than that of the section officers. Same was the case here. Also, at one point of time, these people, that is the section officers, they were getting more salary than the bench clerks. But later on in the revision, the bench clerks got more salary. High Court said we cannot, the Supreme Court said we cannot interfere. Mainly because at one point of time you are getting more salary. Now, Your Lordships, you may kindly come to page 169. Actually, the judgment which is being referred to is at page 168, para 11, Mewaram Kanodia versus All India Institute of Medical Sciences. Actually, this is 1989 volume 2 SCC 235, para 11.4.
Should I just confirm with the client? They said that they were not getting the as per the settlement क्योंकि settlement ultimately कभी पहुंचा ही नहीं, उस पे act upon कभी हुआ ही नहीं, and they were not getting with respect to the
We
settlement.
go by the records, madam.
हाँ, नहीं,
Your
नहीं,
instructions will not really work.
नहीं, absolutely your leadership. Therefore, I just showed that.
11.4, Your Lordship. This court held that while there was a qualitative difference between the two posts on the basis of educational qualification, and therefore the principle of equal pay for equal work could not be invoked or applied. It was further held that a third pay commission had considered the claim of hearing therapists but did not accede to the grievance made by them. Since the pay commission was in a better position to judge the volume of work qualitative difference and the relatability and responsibility required for the two posts, this court declined to accept the prayer made by the petitioner under the principles of equal pay to equal work. So if the qualification, they have not given any, brought on record anything to show that qualification wise also there was any similarity. Discharge of work, admittedly they say it was not similar because they were they claim themselves as productive workers and those are non-productive workers. As per them, now Your Lordship, same page, if Your Lordship comes to the next judgment, Griha Kalyan Kendra workers versus Union of India and others, Lordship, para 12.3. In the first instance, has the Lordship got this part? In the first instance, this court endeavored to deal with the question whether the employees of these workers were denying them wages were being paid to other similarly placed employees doing the same nature of work. The question came to be examined for the reason that unless the petitioners could demonstrate that the employees of the Griha Kalyan Kendras were being discriminated against on the subject of pay and other emoluments with other similarly placed persons, the principle of equal pay for equal work would not be applicable. During the course of first adjudication in the writ petition in such and such, the court requested the former Chief Justice of India to make recommendations after taking into consideration as to whether the other similarly situated employees engaged in similar comparable posts putting in comparable hours of work in comparable employments were being paid higher pay, or if so, what should be the entitlement of the agitating employees so as not to violate the principles of equal pay to equal employment. Secondly, if there was no similar comparable employment, whether the remunerations of the agitating employees deserve to be revised on the ground of their remunerations being unconscionably and unfair, and if so, to what extent? The report filed by the former Chief Justice, it was concluded that there was no employment comparable to the employment held by these engaged Griha Kalyan Kendra. Therefore, they could not seek parity with other employees working either with the New Delhi Municipal Committee or Delhi administration or the Indian Committee. Based upon the factual conclusion, this court held the concept of equal pay for equal work implies and requires equal treatment to those employees similarly situated. It was held that a comparison could not be drawn between unequals. This is important. Since the workers who had approached the court in the present case has failed to establish that they were situated similarly as others, and it was held that could not be extended the benefits which were being given to those whom they claim parity. In this behalf, this court also opined that the question as to whether persons were similarly situated equally had to be determined by the application of the board and reasonable test and not by way of mathematical formula of exactitude. Therefore, since there was no other employees comparable to the employees working in Griha Kendras, the court declined to entertain the prayer of the petitioners. So there has to be some reason why also they can be allowed the pay scale of the other daftaris and regarding another thing, if the pay scale is fixed, is unreal or unconscionable. It can be unreal, unconscionable, or unjust only when it is below the minimum wages guaranteed by the state government. Their claim is that they were getting as per the minimum wages. Our case is they are getting more than the minimum wages as per the settlement of 1985.
Madam, you come to page number 20 of the internal page 20 of the report. Paragraph 20 on the impugn note, paragraph
20. Yes.
28. Please read it slowly and carefully.
The workman's stand is that prior to coming into existence of MITCO, the workmen working in MICA division of MMTC were getting MMTC pay scale, and the concerned workmen being from productive side were getting higher wages than that given to the workmen from non-productive side, the detail of which are already mentioned above. But after creation of MITCO, when pay scale was fixed, very surprisingly, the concerned workmen were given less wages, and the other, namely the workmen of non-productive sites, were given MMTC pay scale, and quite obviously, therefore, there was a discrimination which the concerned workman was subject to without any justification
Pause here for a
whatsoever.
moment. After creation of MITCO, when pay scale was fixed, right? There is a fixation of pay scale with the concerned workmen. A pay scale was fixed for them.
Is that
Very surprisingly, the concerned workmen were given less wages as compared to the workmen of non-production side. Right? So after you merged with MITCO, a pay scale was given to you. It's not that you were not given any pay scale, but
That
you were agreed by the pay scale given to you as compared to those to whom a different pay scale was given.
That is what earlier I submitted your leadership, that they all were working together in when they were appointed in the 1972 region. When they petitioned, a bunch of people were shifted in the year 1977. A pay scale, I said that earlier there was no pay scale, therefore 5 rupees and 5.2 rupees and 5.92 rupees has been referred to therein. But then when they
Do you want to say that if at the entry level, two different categories have the same pay scale, at the entry level, let us assume for a moment, one has a higher pay scale then subsequently also the person who is having a slightly lower pay scale is not entitled to any higher pay scale at later point of time,
Your Worship, it depends
or
on
that difference has to be maintained throughout.
that it depends on the nature of the work also, Your Lordship. The pay
The
scale depends on
fixation
the
of pay
work.
scale and the increments etc. is different for different categories, completely different.
Yes, Your Lordship,
How
and
do
that
you
depends
mix
on
and
the
match? How do you mix and match both the things?
that is what the learned labor code said, that this difference, this discrimination, one where pay scale was fixed at a higher, mine was fixed at a lower, when I was getting at a higher amount. What is the basis of this? That they have to state, which have not been narrated. What was the basis of that? When I was getting a higher pay scale or higher daily wages as per when I was there, then suddenly on transfer, why I was fixed at a lower scale? That reasoning is absolutely missing. That has been also observed by the learned labor code.
When you were there in this MMTC, you were not against any pay scale.
No.
You were not against any pay scale. Pay scale has been fixed for the first time when you entered Midco. So you cannot say that at MMTC you had a different pay scale. You never had a pay scale in MMTC. Your pay was fixed as per the wage board from time to time. You never had a pay scale as such, isn't it?
When we were transferred to, yes, it can be said, because earlier it was 5 rupees, 5.25
Yes,
rupees, and
it was never a pay
5.92
scale.
rupees.
Pay scale has been fixed for the first time when you entered Midco. So you cannot say that you were in a different pay scale and then corresponding pay
I
scale.
am always saying that I was being paid at a higher side from them. From the reading also, Your Lordship, my WS, it is stated that I was being paid at a higher side from the other person. When this was, there has to be
minimum
certain
wages
reasoning,
being
Your
paid
Lordship.
at the higher side is very different from a pay scale.
There was no pay scale at that time. That is what I am repeatedly submitting before Your Lordship, that there was no pay scale. But when a pay scale, when I am getting something higher to the person who are maybe in a different category, but I am getting here, why suddenly my pay scale decreased and their pay scale was fixed at a
Your
higher
pay scale has not decreased, your pay has decreased.
My pay has decreased.
It is not a decrease in pay scale. For minimum wages, you have been given a pay scale.
Two different scales. Why it has been
Is it your case that whatever minimum wages was being paid to you, you were paid even less than that?
No,
that is not your case.
No, that is not my case.
That is not your
submitted
case.
that is not my case.
So, it is one thing to say that if a person is in organization A and he shifts to organization B, he cannot be put to a disadvantageous position with respect to his pay scale, his pay and emoluments, etc. Right? But so therefore, when you shifted, you were not put under any disadvantageous position. So far as you yourself, as compared to yourself, is concerned. It is another thing to say that another person who was working in a different post for different purpose, he was given a better treatment than you. He was given a better treatment than you. This is the fact of the case.
This is the fact
that he was given a better treatment.
That discrimination which has been adopted
So therefore, there cannot be any discrimination between two persons of different categories.
Rashid, never it is my case, it is their case which they are building up, that we are seeking parity. We are never seeking the parity. We are seeking a clarification. When we were getting a higher pay, why? I'm not using pay scale, I'm saying pay. Why and suddenly on what basis my pay has been decreased? Your ladyship may kindly come to para 30 of
It is not the
judgment.
terms of reference that the pay scale fixed.
I am saying
whatever pay scale was fixed to you by virtue of 1985 settlement, right, is itself bad in law. That is not the terms of reference.
That what should be the pay scale and pay structure of the workmen of various units of Mica Trading Corporation situated in the Bihar, and on what basis they are entitled to get their DNS allowances. This was the reference page. Your ladyship may kindly turn to page 22, internal page 22 of the improved judgment, para 30. The reasoning has been discussed by the learned labor code. I may be permitted to read this. As is already noticed above, prior to creation of Midco, the concerned workmen were getting more wages than those who later on were getting MMTC pay scale. the plea of gross discrimination on the part of the management
No,
has been taken
The
by the
concerned workmen were getting more wages than those who later on were getting MMTC pay scale.
concerned workmen means who are in dispute before the labor board. They are getting more wages than those who later on were given MMTC pay scale. The plea of gross discrimination on the part of the management has been taken by the concerned workmen, and it has been submitted that there was no justification at all of not providing the concerned workmen the same pay scale as given to the others.
Even
As-
prior to shifting to Mitco, you were not getting the same pay,
I was getting higher.
maybe higher,
Yes.
but not the same.
I was getting higher.
But not the same.
Yes.
Right? But not the same. So you were never at par with the others.
Your ladyship, from the deposition also it has came when I was shifted to Midco in the year 1977. I was not even informed. I was not even told about the situation that is
You
there
should
in the
not have
deposition. I should have not joined.
Certainly not.
That is there in the deposition of my witnesses that
Why
I
did
was
you
not. Your ladyship, I was not informed. And then later on, when we came to know that this is the, because they are not very much educated people, lordship, they was not what the internal arrangement. Lordship, internal arrangements
They are
क्या हो रहे
educated. You
हैं?
see, they might not be educated, but they know how to fight out the trade
इंटरनल
union
अरेंजमेंट्स
case.
क्या हो रहे हैं उनको बोला गया कि यहाँ यूनिट से वहाँ यूनिट में वो काम करने लगे हैं लॉर्डशिप वर्क इज मोर इम्पोर्टेंट बिकॉज दे आल्सो नीड टू हैव देयर लाइवलीहुड लॉर्डशिप may kindly see further of this
You
particular
want to argue further?
lordship I have not started argument there are various points raised
That's
I
right.
have not
That's right. That's right. We are now in the grip of the matter. We know. If you want to, both of you, if you want to put something in writing, please do it. I will post it there. थोड़ा सा मेहनत कर लीजिए क्योंकि कोई चीज छूटना नहीं चाहिए.
बैच केसेस फिक्स किए
Day after tomorrow के लिए batch
और
cases.
कल वेडनेसडे
एक ऑर्डर शायद अपलोड किए हैं उसको. टाटा पिगमेंट्स का एक ऑर्डर अपलोड.
टाटा पिगमेंट्स टाटा कमिंस लॉर्डशिप
अच्छा डे आफ्टर टुमारो वो रखे हुए.
मंडे को रख दिया
नहीं Monday नहीं because I have a backward matter in court 14
अच्छा okay. Day after tomorrow you have that matter. Can you prepare the note for the purposes of going through the note? I can post it day after tomorrow. Is it possible? Your junior is there. They are so competent. और तो इतना पूरा सुन रहे हैं पूरे समय है she will prepare it and you get it. अब तो आप सीनियर हैं आप थोड़ी बैठ के नोट बनाएंगे.
लॉर्डशिप एक बार इनका
अब आपका
नोट
नोट बनाने का काम खत्म.
पहले भी लॉर्डशिप
Can I
जूनियर्स
sum?
बनाते थे
हाँ
पहले भी जूनियर्स का चेंबर में सब जूनियर्स थे आर्ग्यू आल्सो
तो ठीक है यही जब यही बनाएंगे फिर क्या
May I
दिक्कत?
just submit that let them submit the written argument
नहीं नहीं
lordship.
ये
And
simultaneous-
accordingly मैं
नहीं, accordingly नहीं
whatever I
होगा,
have to
नहीं।
revert it
नहीं
back
नहीं रिवर्शन यहाँ पे कोई काउंटर एफिडेविट नहीं फाइल करना. You have to do it simultaneously. Whatever be your case, you have to do it simultaneously and exchange simultaneously and submit it to them.
but I have not started I have to argue a lordship
I will hear you. I will hear you. It's not that you have started not. आपको ऐसा कोई रिवांस नहीं हो. Okay, but you prepared a note.
बस तो एक चीज बोले फ्राइडे को रख दिया जाए
For
Friday
preparation
only
for
for the
filing
purpose-
of note.
फॉर फाइलिंग ऑफ
The matter has been substantially heard. The council for the parties are
फ्राइडे इज हॉलीडे
Friday is a holiday.
यस
Monday को note.
अब मंडे को नोट
Monday your lordship
अरे note
हाँ
खाली
note
लगा.
note note
The learned council for the parties are directed to prepare short note so that the records have been extensively placed during the course of hearing. However, the learned council for the parties are directed to prepare short note or / synopsis of arguments and also refer to the judgments which they have relied upon during the course of hearing or they wish to rely
Yes.
upon it with paragraph numbers.
यस
Interesting after this.
बिकॉज़ आई अंडरस्टूड दैट इक्वल पेपर इक्वल वर्क इनका केस नहीं इन जजमेंट्स में बोला कि कब पेनल्टी दिया जा सकता है कब कंपेयर किया जा सकता है
इस लेवल तो मेरे लिए भी है
Ladyship, that supplementary CU7 is a content matter and it has been complied with it. So maybe
Where is the petition?
behind the petition.
Okay.
Actually, sir was continuous.
The serial number 7.
CU
The
is
council for
supplementary.
the petition submits that the order passed by this court has been complied and he does not want to press the complaint, contempt petition.
Lordship, I did
Your
wrong.
grievance has been
Grievance has been resolved.
redressed.
Redressed.
Considering the submissions, the
Lordship, check
the
already उसी दिन Friday को receive कर लिए थे during.
contempt is brought.
Yes, sir.
Supplementary show cause has been filed, which is taken over.
Appearance is.
What's your name? Give your appearance.
Ishan Ashish, please.
Isha.
Ishan Ashish.
How about ये Monday को रहेगा. Post on Monday for the purposes of filing your consumptions and for further hearing. उस दिन hearing नहीं करेंगे. Monday no hearing because I do not know. You are not available for further hearing. उस दिन hearing नहीं होगा. We'll just keep a date. You just